definitely good viewers afterwards. So thanks again. And Kim, if you can kind of, feature, Laura, are you gonna speak as well?
I can. I'm happy to if you'd like me to. I didn't have anything prepared, but you know me, I can wing it.
No, so I'm gonna have you just present Heidi first, and to everybody. But first of all, thanks for joining everybody. That's our bi-weekly KW Commercial SoCal meeting, and we enjoy showing up every other week virtually still, and provide you guys more value and insight. And Laura Peterson, she is leading our risk management firm. She's based out of up north in Sacramento area. So she's gonna open up, and we have great content, and looking forward to it. Laura.
Okay, thank you for having me here this afternoon. One of the benefits of RERM, I know we spend a lot of time talking about residential, but there's also great benefits for commercial. And I want you to know that those benefits are there, those protections are there. Today, we have two fantastic attorneys that are going to talk to you about some issues involving commercial real estate. We have Rinat and we have Heidi. I can't say enough about Rinat. She and Heidi, I haven't worked with that much yet, but Rinat has said fantastic things. But really listen to the advice that they give you. It is very valuable. Please interact in these presentations. Send your questions through the chat. I know that nothing is more boring than when you're presenting and you get no feedback and no questions. So please get those questions out there. And if you need additional services after this presentation, please make sure that you're coming to RERM. Don't go to the attorneys directly, because if you do, you can be responsible for those legal bills, and I want to pay those for you. So with no further ado, I'd like to introduce Heidi and Rinat. Take it away, ladies. Thank you.
Thank you.
Hi guys, can everybody hear me well?
Yes.
Yes.
Okay, fantastic. If my voice gets garbled or something, let me know. I'll figure out. Sometimes it happens on Zoom. Anyway, my name is Rinat Erlich, and Heidi works with me. I have been a broker for many years, and I specialize in defending brokers. I've defended brokers in all aspects of litigation, lots and lots of commercial transactions, lots of property managers, and so forth. And then Heidi specializes in unlawful detainers, lease, landlord, tenant relationship. I heard that you first want to hear from Heidi, but Heidi wanted me to go first, so here you go. I'm going to start. I'm not going to talk about the broker stuff yet. I'm just going to do an introduction about property managers, okay? Because that to me is where this all starts. And do I want to start with bed bugs? Probably not. You see? Okay, this is not the right. Give me a second. I'm sorry. I have so many screens open here on my computer. I'm trying to attach the correct PowerPoint.
And just to make sure we're not after.
Oh, I know what happened.
Presentation. We're gonna. I guess Heidi's gonna talk about the eviction part, correct?
Yeah, she's going to start with the eviction part.
Okay, got it.
Okay. We have a PowerPoint, and for some reason I'm not sure. Wait, let me see now. I do apologize, guys. I'm so sorry. Why is this working? Let's see if this is going to work. What am I sharing now? I'm sharing my email. Okay, that's not going to work. Gosh, I'm so sorry.
Did you maybe want Heidi to, oh, there you go. Avoiding claim.
Okay. Nope, that's not it. Sorry, guys. This is it. Yep, this is it. Okay, so first of all, my sincere apologies. This should have never happened. Let me start from the beginning. The way it works with Zoom, I can't do a slideshow, so I'm just putting my slides here very tiny, and then you're just going to see my screen as I'm opening them. The reason I have a slideshow and like to have them is that it gives you something cool to look at. You don't have to look at us the whole time. Okay, so here are our numbers. According to Laura, you should not call us directly, and I'm not trying to encourage that, but if there's an emergency, you know, late at night, weekend, whatever, and you can't get hold of Laura, these are our numbers. We'll send you the PowerPoint presentation. You don't have to write the numbers now. This is what I wanted to start with, okay? So where the intersection between commercial agents and eviction happens when you act like a property manager. Now, I don't know how many of you actually have an actual contract with your clients to be a property manager, but what I want to do in this slide is to tell those who do not have property manager contracts with their clients that you might actually be acting as a property manager. Now, why do we care about that? So I've made a career out of defending brokers, as I told you, and I defend them in actual lawsuits. This means that, I don't know, we get 5 to 10 lawsuits a week. So a lot of them involve property managers. A lot of them involve botched evictions. So what you want to know is when you're a real estate agent working for your buyer or seller, is that when you take on responsibilities, you may be acting as a property manager when you do these evictions. And if all you really wanted to do is refer your owner to the attorney who does the eviction, then please just do that. You definitely don't want to take on responsibilities of serving notices and doing other stuff that typically somebody who's not a property manager won't do, okay? Now, so what makes you the property manager? It's going to be a question of fact. So if you are saying to your client, look, I'm not going to manage your property. Yes, I sold it to you, but now you're on your own, or here's a property management company I recommend. It doesn't mean you're not acting as a property manager if you don't have an agreement. What are the issues that are going to come into play when the judge or the jury evaluates those facts? They're going to look at what you did. Did you collect rent? Did you set the rent value? Like if your client asks you, hey, well, how much should I rent this office space or this store or this property, you know, residential property, and you give them opinions. Well, doesn't mean you're a property manager, but it's one of many facts that the trier of fact is going to look later to decide if you were a property manager or not. Did you help them with budgets? So I have here different things that I suggest. I could tell you screening tenants, so many lawsuits I got about screening tenants because you might get in an application. What do you do with the application? First of all, does it follow all the new privacy laws? I have 2 class actions about that. If you don't give them information in the application that they're entitled to get the result of the credit check, you could be liable for that. Now, let's say a lawsuit comes in that you didn't follow up the privacy laws. You turn around to your owner and say, you owe me indemnity. But wait a minute, there's no contract because you didn't think you were a property manager. You were just doing a favor. Maybe you were even just sending an application to your owner client and saying, hey, you could use this application. I typically use it, or something like that. So you want to be very clear with what your responsibilities are. And if you do not think you're a property manager because you are not being compensated as a property manager, then please don't act like a property manager, okay? If you want to be a property manager, I don't have a problem with that unless your broker does. And some brokers don't let their agents be property managers. And if that's the case, that's something different. But if you are and your broker allows you to be a property manager, make sure you have a proper contract. It would have indemnity, it would limit your duties, and if you want to expand your duties, only do that in writing, okay? Now, especially collecting rents is another problem. And the real problem with collecting rents is with the DRE. because what the DRE likes to do, it likes to look at the trust account and audit them. And that's kind of a pet peeve for the DRE. Well, where do you have the majority of issues with trust account? In property management, right? Because you collect rent, you're supposed to put it in a trust account, and then weird things start happening. And I've had those DRE complaints before. So if you collect rent, even if you're just holding it, even if it's for 2 seconds, even if you're just doing a favor, it doesn't matter. If you collect it, you have to put it in a trust account, okay? That's what the rules are. So these are the little nuances that I always get worried when my clients either act as property managers or don't know that they're acting as property managers, okay? The second slide I wanted to talk about before we go to evictions, very important. When you, if an agent gets sued, they get sued for 2 types of claims. One is a tort, meaning, somebody commits a tort like misrepresenting, breaching fiduciary duty, being negligent, and one would be a potential breach of contract. And there are a lot of nuances, but this is very simplified, okay? Now, what is your duty based on? It's based on contract, it's based on the law, but the contract doesn't have to be in writing for you to have a duty. So for example, if you're an agent in a commercial transaction, and I have that case right now in the office, and the agent says to his buyer, I manage a lot of properties, I could go through every unit and tell you what's wrong. Well, that buyer gave up a home inspection, or not a home inspection, but a property inspection report, because he thought that the agent was qualified enough to do a property inspection. But of course the agent is not qualified to do a property inspection. They're not trained to do that. They're not hired to do that. They don't get paid to do that. So this agent goes now and does a property inspection, goes from unit to unit and said, electrical issues, plumbing issues, makes a list. So now this agent has become a property inspector. Now, if you want to be a property inspector, by all means, but please don't be a property inspector without intending to be a property inspector. What does that mean? That means that, going back to what I explained to you about lawsuits, you're going to have a duty determined by law, and the law doesn't say your duty extends to being a property inspector. It's going to be limited by contract if you have a written contract, or by an oral contract. The oral contract is the stuff that's not written, where we always get into trouble with, because people say, you told me you're going to do this, or you told me you're going to do that. So this is the purpose of this slide. Are you a lawyer? Absolutely not. In fact, if you practice law, you're going to be practicing without a license unless you're also an attorney. Are you an inspector? No. Are you a property manager? Well, if you don't think you are, then you're not. Are you a loan broker? I have that case too right now in my office, where a real estate agent was helping a buyer get a loan, and they got a commercial loan and some complication, bad loan, and now they're blaming the real estate agent for that, even though they did not act as a loan broker and they didn't get paid to be a loan broker. Same thing about investment advisor. How much you should list your property for, how much you should purchase this property for, sharing comps. We had a trial in the office last year where the claim was that the commercial agent did not provide the all the leases to the buyer, but told the buyer that they could evict these tenants, because the buyer was going to basically evict everybody, demolish the property, and build a new building. They ended up having to buy out that tenant. So that was the claim. So again, it goes to the investment. Your buyer is planning to build a development? Great. That's out of my depth, out of my expertise. I'm not going to tell you who you could evict and not evict and so forth. So with this introduction, now you're going to get to hear from Heidi.
Hi. So I'd like to get some information. I was under the impression that we had brokers who were handling commercial and multi-unit. So I can talk about both. Okay, I hear
that's
I
correct.
Have a face nod. Okay, so I want to make sure that I can address both issues. I'll start with the residential. As you know, the last 2 years have been very eventful for residential evictions. not just with COVID, but prior to COVID, there was a new statute that came into effect in, well, it was passed in July of 2020, but went into effect in, I'm sorry, it passed in January 2020, but went into effect in July of 2020, which affects the entire state of California. So prior to July of 2020, if you weren't in a rent stabilization ordinance city, you were not precluded from serving a 30 or a 60-day notice or terminating a tenancy at the end of the term. You had a lot more freedom to get your property back. In July of 2020, that ended unless your property was exempt. And there is a relatively broad exemption for certain properties, single family homes, duplexes where the owner lives in one side, shared homes where the owner rents out rooms, condominiums, townhouses, things like that. They homes that are under 15 years old, things like that, new builds. Those were exempt properties, so you had still the freedom to not only increase rent, but also evict based on end of term or 60 notices, and get your property back. Things that were not exempt, you had limitations. You could only evict for certain no fault or at fault was still, I mean, if they didn't pay their rent, of course, if they breached a covenant in the lease, or if they committed a nuisance, things like that, those were still available to all properties. But they limited no fault just cause types of evictions, and those were limited to owner wanted to move in, the owner wanted to move in, they want to move in a family member, they want to take it off the market, things like that, or or a tenant gave notice that they were moving out. So in the no fault just cause, you had to give, well, both. You have to give proper notice. Any tenancy over a year is 60 days, anything under a year is 30 days. And if it was a no fault just cause, you had to serve, or you had to pay relocation. And that relocation under state law was the equivalent of 1 month's rent. And you could either pay them that within 15 days of the notice, or you could give them notice in the, tell them in the notice that they were going to get their last month's rent, but that had to be in the notice. What I'm finding with the state law, with brokers, which is creating a lot of exposure for brokers, is that there's a requirement for exempt properties. Well, there was a requirement for all the properties that you had to give notice of this new law. And I'm sure you're seeing all the forms, the rent cap forms, and you're serving them with your new leases. But when the law started back in July of 2020, you had until August to serve all your existing tenants with that notice. And at the bottom of it, there's a section that says exemption. You have to check that if your property is exempt. And it gives your tenant notice. And if you don't make that check, your property is no longer exempt. You lose the exemption by not check marking off that the property is exempt. And you don't get that exemption back until you have a new tenant come in, or you can do it at an addendum. So at the end of the year, if you want to do another year lease, you can include it in there and recapture it. But it's something that I've noticed that a lot of brokers don't know about. They give the rent cap form, the notice, but they're not check marking it. Without check marking that, it's a big problem. Your client is losing the ability to negotiate their property. And that could become a big problem for brokers. So they had until August for the existing tenancies. And then for any new, it has to be in the lease. And so I know that the CAR, the new leases all have the exemption, I'm sorry, the notice and the exemption check mark. And in that case, most of the brokers are serving them, but they're not check marking that box. So that's a big issue with the state law.
Does anybody like have question about where to check mark the notice? Because this is an example where when you're doing a lease, you're really not acting as a property manager, you're just a leasing agent. And if you don't give this proper notice and you don't check the box, your owner is going to go try to evict a year later and they're toast. They can't evict based on this based on missing this exemption. So they go back to you and say, you negotiated this lease, you screwed up. Do you guys understand that? So if it's not clear, maybe we can send an email to everybody with a copy of the form where you actually need to mark. But I just want you to know, this is an example. I'm not asking you guys to go do evictions these days, right? So all these laws that Heidi's mentioning are good for you to know, but you're not going to sit there and try to sift through the law. But when it comes to drafting a lease, that's on you.
Yeah.
Okay, so just want to make sure you're paying attention.
Yeah, and unfortunately, I think that the law was designed for you to miss it. And there's no politics in that. I just think that the way it was drafted, it was designed for you to miss it so that they would capture all the properties in the state of California under rent control. There's a lot of laws out there that, the Constitution, there's a lot of litigation about holding people's property hostage. And they want to say to you as an owner, oh, we acknowledge your right as a property owner to keep your property, but at the same time, we're going to establish a law, which we're not going to tell you about, and we're going to require you to do things that you're never going to know about. I just had a conversation this morning with a gal who is desperate to get her tenant out, and I have to go through the steps of show me your lease, where does the notice, did you check it? She didn't know any. She had no idea what I was talking about. And the broker who helped her, nice guy, but he isn't the property manager, but he did help her with the lease. And so that's where you are. That's exactly what Rinat was saying, is she could now go back to him and say, hey, I gave away a right that I had. Why didn't you tell me about it? So it's a tough situation, but so that's the new state law. The COVID laws, I'm not sure if, I'm sure everyone knows the COVID laws. I'm not sure everyone knows the status. The city of LA is, the moratorium in the city of LA will continue until, well, it's for rent, it will go until a year after the end of the state of emergency. And what that means is not that you can't evict for new rent once the state of emergency is over, but you can't go back and try to get old rent until a year after the state of emergency ends. So I would not anticipate doing, and unfortunately, the mayor has not given us any idea of when that will end. He has extended it, back in 2020, I said, oh, it'll be over in August. Oh, it'll be over in December. It'll be, I mean, well, in the beginning, we thought every 3 months it would fall off, but now it looks like it's going to be in place at least till the end of the year. And I say that only because the county is ending their moratorium at the end of December. So they tend to be lockstep. But unfortunately, the county does extend once the city extends. So hopefully we'll get some idea of when they will cut out, when the state of emergency will be over as we get closer to the end of the year. But I don't anticipate that the moratorium ending in the city of LA, and that's for payment of rent, that's for excess people in the unit, that's for animals, that's for really the only thing you can evict for at this point is illegal conduct, nuisance. And if it's a nuisance, it can't be a nuisance from anyone who is the manager, on-site manager. It has to be another tenant who is complaining. And the hardest part about that is getting, I'll get to that one second. the hardest part about that is getting another tenant to testify, especially if it's something where they're afraid. You have a tenant who says, you know, my neighbor is threatening me, and you say, okay, well, we'll evict them, but you got to come to court. And that's the difficult part because they're afraid. And if you can't get another tenant to come, you're not going to be able to evict them. So,
let me know when you want me to move a slide whenever you're ready.
I'm sorry?
Let me know when you want me to move the slide.
Okay, someone asked about cash for keys, and then somebody asked for Beverly Hills. You can always do cash for keys. The problem is you can't enforce it. So what I'm telling people to do with cash for keys is, well, so if you're talking about cash for keys in the city of LA, there is a protocol you have to go through because that is an RSO. If it's a non-rent control property, then it doesn't really matter. You can negotiate a move out with a non-rent control property. But the city of LA moratorium is not just affecting rent controlled properties, it's affecting all tenancies, commercial, residential, single family homes, anything that is a tenancy is under the city moratorium. If it's an RSO, you have to follow the protocols and pay relocation, and their relocation is pretty significant. I think it's anywhere from 10,000 to 20,000, depending on the nature of the tenancy, whether they've been there for over 3 years, whether they're a senior citizen, whether they have a handicapped child. Those would be on the higher side of the relocation spectrum. If it's non-rent control, yeah, you can do a cash for keys, but I do not recommend giving money before they vacate, because if they don't move out, you've now paid them money and you have no mechanism to remove them from the property because of the moratorium. Now, in the state of California, if a tenant, for a cash for keys, if a tenant comes to you and says, I'm going to move out, let's negotiate that move out, I want you to pay me, or I want, or whatever. Or if you want to do a cash for keys, have them give you a notice that they are moving out. Hey, landlord, I'm moving out on the 12th of August. And then you can use that as a reason to evict. So your tenant giving you notice that they're moving out is a just cause reason to evict them. So make sure when you're doing a cash for keys, you're getting that notice for them that you can attach to the complaint as your exhibit that they have to bring you within the just cause parameters of the state law. So Beverly Hills, they're all very similar. Beverly Hills, the nice thing with Beverly Hills is they are requiring proof of your COVID hardship. So your LA City is self-certifying. I've told you I'm having a hard time because of COVID. I'm not making enough money. You don't have to show the landlord any documentation. You will have to show documentation in court if you know, once it opens up after the moratorium, you'll have to show evidence. But in Beverly Hills, to be able to capture the protection of the moratorium, you have to show proof that you are entitled to, that you have a hardship. I'm missing some of these questions. I'm sorry. So the city of LA is difficult because they have put a cap on all evictions, commercial and residential. So, and they're not, it would have to be a breach of lease where they're doing something that's dangerous, rather than just conducting other businesses. So it would have to be something that was illegal, maybe zoned for it's not zoned for that area. It's, you know, using flames inside, something that would create a danger rather than just doing other commercial business. Oh, I got them all. Okay, so I think I might be done with.
Here's commercial.
Yeah, so, oh, we're doing commercial. Okay, so timing. I didn't make that, but I'm assuming you mean how long does it take for an eviction? I would say evictions. So the complication of evictions is not the process from filing to end. The problem with evictions is the involvement of opposing counsel. So as soon as you have, because if I file an eviction and they don't respond, I can get a default judgment and have a tenant out within 6 weeks. If I get an opposing counsel who is cooperative and we enter into a stipulated judgment, it's similar timeline. If I have an opposing counsel who's obstructive, it can go and they take it to a jury trial. I've had trials go on, not come to trial for a year. So it really depends on who's on the other side and how obstructive they are. So normally what I tell my clients, whether it's commercial or residential, you always have to be open to settlement, because this can take forever. They can file bankruptcies, they can file removals, they can do whatever they need to do to disrupt the process, and make it take as long as they want to wear down the owner. And you as brokers, the conflict you have is that you are usually the ones who initiated the eviction. Hey, the tenant didn't pay the rent. We need to start this eviction. And the owner's like, okay. And then it takes 6 months. And so who are they going to look to? They're going to look to you as the reason why they haven't gotten rent for 6 months or haven't gotten the tenant out in 6 months. So the more willing you are as an owner, and as a broker who's influencing that owner to settle, to negotiate a settlement, the happier everyone is going to be, and the least amount of fees that are spent, the loss of rent. So it's important to come to an eviction with the mindset of settling and resolving the issue without going to trial.
I just wanted to add, Heidi, you guys could hear me?
Yeah.
Yes? Okay. What tenants do more often that I've noticed is evictions are only about possession of the property. They're not really about anything else between the landlord and the tenant. If the tenant, for example, claims they had an option, or if they claim that they're due money because they suffered personal injuries from mold or anything like that. So what they end up doing is they file a regular civil lawsuit, which according to current timing could take 2 years at least until it goes to trial, because everything is so delayed because of COVID. So it just all backed up, and then criminal trials get priority. And then they try to consolidate both the unlawful detainer with their lawsuit. And if they're successful in that, now forget it. Now you're talking about years. So just so you know, that's also something that we're always worried about.
Yeah, it can become a big problem. So the process is, any eviction is always going to start with a breach of some sort. That's the whether it's payment of rent or a term lease, a covenant breach. And then the next step always has to be a notice, whether it's a notice to perform a covenant, whether it's a notice to pay rent or quit. So I want to talk about that with regards to residential, only with regards to issues that I see about residential notices that are going out. There is the thing with California is there's always specific language in that have to go in notices. And usually they're actually in the code section themselves, verbatim. And you can go and read it and cut and paste, and that's your notice, because it tells you, you have to have this in here. So with residential, you have to always have, especially with a pay or quit, the person to pay, and it has to be a person. It can't be, pay so-and-so brokerage or so-and-so company or the office assistant. It has to be a name, Barbara Klein, or whatever. You can say, Barbara Klein, and put 3 or 4 different names on whoever's going to be in the front during that week. Or it has to be, it can be, I forgot what I was going to say. So it always has to be a human person. And it also needs to have an address where to pay. And it has to have a time. So and it has to be Monday through Friday. It can't be a Saturday or a Sunday. Well, you can add a Saturday, Sunday if you're going to be there, but those days are not counted towards the 3-day pay. So it's sort of irrelevant, but it has to have a times as well, between 9 and 5, between 11 and 7, whatever. And the 3 days are only counted, they're only business days. So there's no holidays and no weekends. So if you serve it on a Friday, the first day starts on Monday. So your best bet is always to serve it on the beginning of the week to be able to capture the shortest amount of time on the notice. So there's other ways that you can put in the notice. You can have wire transfer, you can do direct deposits, and those have specific rules. But what I see the most is personal, payment in person, and those things have to be in there. With regards to commercial, they are, and also with the residential, they have to be to the penny, and there can't be any fees. There cannot be any late fees. There can't be anything other than rent. And that has to be to the penny. If they find 5 cents over, you lose your case. Commercial, it's different. You have much more flexibility. I'll get to you once I get over. If you have much more flexibility in the commercial setting, because you can do estimated notices. So all your notice should be, and they should say on it, estimated notice CCP 1161.1, and the estimated notice just has to be 20%, give or take, from the actual amount due. So, and you can include, as long as your lease allows for fees and CAMs, the common area maintenance charges and things like that, as additional rent in the lease, and most AIR leases have that, then you can include them in your notice as well. And you can also, you have to put in, you can also accept rent during the eviction, as long as you don't exhaust the notice. So say you have a $50,000 notice that goes out, and they're paying you $1,000 every month. You can continue with the eviction as long as they don't pay off the whole amount. So if they've paid $49,000, you need to not accept any more rent. So, and if you intend to go forward with that eviction, if you don't, then collect the rent and move on. But and also, each time you get money from them, you need to send them a notice saying that, that it's called a non-waiver notice, that our acceptance of this rent is not waiving our right to continue with the eviction. So, and that's the nice thing about the commercial notices, is they're much more flexible. They're much more error friendly. So if you make a mistake, you can, as long as it's within 20%, you're okay. The difference between the residential and commercial mainly is about the lease, because the lease really determines a lot with commercial. It tells you how to serve. There are statutory ways that you're supposed to serve notices, personally, subservice, or post and mail, but you have to look to the lease as well, because it may say you have to email 9 different people to be able to serve a notice. And if you don't do that, the lease said you had to, then you won't win your case. So with commercial evictions, always look to the lease first when you have a question on how you're supposed to conduct yourself with regards to notices and evictions and payment of rent and things like that.
So I want to add something, Heidi, about notices, and then there's 2 questions for you. So the first thing I want to say is this: we defend attorneys. We handle legal malpractice cases in the office, and mainly that when they have an underlying real estate case, because that's our specialty. And I want to tell you, when Heidi was going through the notice issues, 2 lawsuits came to mind. One is the attorney who filled out the 3-day notice forgot to put something in the address. I forget what it was. I think maybe a suite number or something. And they go through a 1.5 years worth of litigation in the unlawful detainer, because the other side had an attorney and they were fighting everything and this and that. They get to the trial and they ended up losing the trial because of the notice. So now this this tenant lives in the property for another year and a half, and they basically have to start all over from scratch because there was some typo issue in the notice. So it's so hyper technical that a tiny mistake is very significant. The other case I had was when the notice of the 3-day notice included an amount above the rent that was due. The attorney included his attorney's fees, which they were entitled to under the lease, but you can't include it in the notice. So what happened was he ended up getting an eviction, and then the tenant went and hired an attorney and came back after our client and basically said it was a wrongful eviction. I'm entitled to emotional distress. I'm entitled to all my attorney's fees. And all this time that it was wrongfully evicted, I had this stain on my reputation. I couldn't get another property because of this eviction notice, and it caused me a lot of damages. So wrongful eviction notices are prevalent, and they allow damages above and beyond what you would think, like just for example, just the lease, the rental payments. They allow punitive damages. They allow, like I said, emotional distress. So there are a lot of other things. It becomes a huge case. I wanted to tell you, Heidi, to look. There's 2 questions in the post. One is City of LA commercial landlord, are they allowed to raise rent? And the other, can we increase rent on a house in the City of LA? If yes, how much per year?
Not during the moratorium for the city of LA.
How about commercial?
For commercial, I believe it's the same in the city of LA, but I'll have to verify that. The problem is the commercial, my gut is that no, you can't increase rent right now, but I will verify the commercial. But I know in the city of LA for residential, no, you can't. Not until the end of the moratorium.
Okay, so now that we talked about eviction, and by all means, if you have any questions, we could stay late and answer them or email them to us or put them in the chat. We wanted to talk a little bit more about things you need to think about if you're acting as a property manager for a landlord. So the most important thing starts and ends with the lease, right? Whatever is in the written lease is what holds. Heidi mentioned that a few times. She mentioned in a commercial transaction, the lease even binds how the notice occurs. So you want to make sure that all these things are addressed, whether it's cannabis, for example, if your tenant wants to rent and use it for cannabis. If that's the case, you might want to add indemnity and insurance and some other clauses. Issues about noise, notices, and all that. So just make sure that whatever your owner tells you they want in the lease gets in the lease, because then they're going to blame you that it wasn't in the lease, okay? And then the second thing is that all the funds have to go through your trust account. I talked about that as well. I don't know, Heidi, do you want to talk about this, or do you want me to go? I think you should go.
Well, is this an ADA claims? So
I just want to talk about, as a property manager, the things that you need to worry about in terms of the tenants that are occupying the property that you're managing.
So with regards to, I've handled a few cases that were ADA claims, and what happens, it's only with, I can't say that, because they do large, they do hit large multi-unit complexes, but mostly commercial. So that what happens is firms that handle ADA claims they have a person that they use, or 5 people that they use, and they send those out, and they're handicapped. Usually the ADA claim is legitimate. There's something wrong, but it's usually a minutia. But they send someone out and they try to access the property. Either it's a ramp, or it's the parking location, or it's the opening to the bathroom, or things like that. And then, a couple months later, the owner of the property and the tenant get a letter from an ADA attorney demanding, I fall down on purpose too, yeah. But they demanding the statutory fee, well, not fees, the statutory damages, and they're pretty significant. And so usually what happens with an ADA claim is you pay the damages. you can, what I suggest usually with my clients, I say, okay, get an expert out there to verify it. If it's verified, pay the damages, pay the negotiated fees, and move on, because you will not win a case. You will not win an ADA case if the actual violation is correct. You
So
just won't.
I want to add something, Heidi. There are experts out there that you can hire them for your clients who are buying a commercial property or a multifamily, and they could go through and make a list of what's ADA compliant or not, because the owner is going to be responsible whether they knew about it or not. So if it's let's say it's a restaurant and the restroom doesn't have the ADA access, for example, they could be cited even though they took over a prior place that belonged to a different restaurant from before. It doesn't matter. So both the renter of that space is going to be responsible and the owner of the place is going to be responsible. So it's always good to know if the property is compliant or not. And at least, if your client doesn't want to spend the money to do that, that's okay. Can you please send them a text and say, or an email and say, I recommend you hire an ADA specialist to inspect the property before you purchase it or before you rent it to make sure that it's compliant so we don't get in trouble. If then they say no or they don't do it, they can't come back and say you didn't tell them.
So some of these have requests for recommendations, and we can look at that afterwards and maybe, send out. I don't have an ADA inspector, but I can probably find one. There are a lot of really good ones out there. Luckily, I haven't had an ADA issue for quite a while. So
this is a slide that we wanted to expand what accommodation means. It's not just access to parking, okay? It's everything. So for example, it would include accommodation of a website, okay? There's the website has to be ADA compliant, so people that can't hear or can't see are going to be considered in your website, and there are experts who set up the website to apply to that. It includes all kinds of accommodations that might be financial in nature. So, for example, if you're collecting rent from a tenant who is low income or something, and you're supposed to, under the rules that the rent is under, to accommodate certain things in terms of financial, you can't move from that. You can't change that. So anything that requires a reasonable modification, you might be responsible for. Let me give you another example. You can't talk about other people about, oh, this deadbeat tenant who doesn't have money to pay the rent because they're so poor, or because they're, God forbid, Black or Hispanic, or nationality of some sort or something like that. So just be really careful. Always think, when I think about accommodation, I always think about, okay, forget what the law is for a second. Could I accommodate or not? If I can accommodate, let me just accommodate. I'm going to be doing a good service. Everybody's going to love me. I'm going to get along with my tenants. And if I can't accommodate, then I can't accommodate. So start thinking about that. We have this slide about pets, for example, which is here. If somebody says my emotional support animal are a bunch of snakes, and I need to have 100 snakes roaming around my apartment, that would be unreasonable. You can't accommodate that person because it's dangerous, because they could get out, maybe because they're going to ruin the structure of the unit somehow. So, or same thing with a really big barking dog that barks all day long and creates a nuisance to all the other tenants. So you're walking on eggshells to some extent, because everybody likes to give you the accommodation card. Oh, you need to accommodate me, or this is emotional support. But so be careful in that respect, but it doesn't mean that everything is appropriate. Now, you can ask them to give you a letter if it has to do with pet accommodation, for example, to show that they need it as a service animal, but they don't have to. the law doesn't require them to have to do that, and they could give you just any letter. It could be a friend who treats them during yoga retreat and believes that they need it for emotional support. It doesn't have to be a registered doctor or something like that. So if you ask them to give you a letter, you might be stuck with what they give you. I think a different approach would be, listen, guys, we want to accommodate you. Bring in a small animal, bring in somebody that doesn't bark, or make your dog not bark all day long and all night long. It's a nuisance. So that's really what your approach is going to be.
And the problem with service dogs and EMS dogs is not service dogs. They are highly trained, and they usually, you never have a problem. It's emotional distress dogs because they usually have zero training, and they're a way for a tenant to get their animal in the building. And so you know, for them, you have to kind of watch out for the nuisance, because they can still bite people. They can still, you know, cause a nuisance. And so you can get them out. You can even get a service dog out if they bite someone or they, you know, bark too much. But you're not going to have as many problems with a service dog that truly has a job, because they're so highly trained. So, and
by the way, you know, an example to accommodation could be requiring your tenant to have certain type of insurance, or you could get a higher deposit. But I think, Heidi, you're limited to twice the rent for the deposit for pets, right?
Oh, well, no, pets are just so for deposits, you can do 2 times the amount and 3 times if it's furnished. And pet deposits are technically considered a deposit. So you can't have, you know, 2 months rent plus a pet deposit. It has to be, because it's considered a deposit. So if you're going to do a pet deposit, and you can't require a pet deposit on service dogs or EMS dogs. So it's only, you know, regular dogs.
So I had a case where our client demanded a higher deposit to a tenant who had allegedly a service pet versus the deposit required by other tenants, and they said that the manager was discriminatory.
Yeah, you can't charge any rent or any security deposit, because you have to remember, in the eyes of the law, a service dog is not considered a pet. It is a working dog. So it is not pet. So you can't treat it like a pet. So you cannot increase. And think about this. If I need a service dog for my disability, what if I need a cane for my disability? Can I charge you a security deposit on your cane? No, you can't. The dog is a tool for a disabled person to function properly in their lifetime. So by charging them for it, you are discriminated against their disability. So you can't charge rent, and you can't charge a security deposit for service dogs or EMS dogs.
Before we move, I wanted to answer some questions. So does ADA apply to an apartment building? Yes, it applies to, the law says that it applies to a business that caters to more than a certain amount of people. I don't remember exactly how many, but if you cater it to the public apartment building, they have visitors. So yes, it would apply to that. But go ahead.
Most of your issues with ADA accommodations is going to be from tenants that live there. So you have a tenant that comes in who needs an accommodation in their unit. They need the shower, you know, the shower changed a little bit. Now, you're not required to pay for it, but you have to allow it. So if they need a roll-in shower with no lip, you have to accommodate that, but you don't have to pay for that. They have to pay for it. And usually they get money from the state or the city or whatever to help make any changes. But most of your issues with ADA is going to be in the residential section is going to be your tenants, because you can't just say, you can't discriminate. If someone says, you know, I need accommodations, I want to move in, but I need XYZ, you can't say, I'm sorry, I can't rent to you because that's too much of a pain to accommodate you. So that would be discriminatory as well.
So I just want to make it clear, there's 2 kinds of ADA claims. The first ADA claim is what Heidi talked about earlier, which is you have to have access to certain people in certain quantities. So X amount of disability parking spaces that are marked. Okay, that would be the requirement when you're making when the public is invited in, or you have a certain amount of tenants. The other thing that Heidi's talking about now is a specific tenant making a specific request that is only specific to them. So the claim is not going to be from these ADA attorneys saying, oh, your building is non-compliant. It's going to be from a tenant attorney saying, my client asked for an accommodation, you didn't give it to me. So the first one, you have to have enough parking and all that. That would only be the larger apartment units. It won't be a single family home. But the single family home, if you have a tenant who says that you need to expand the shower doors, might be an issue of accommodation.
So someone asked about the ADA, if you got a default judgment on an ADA lawsuit. So the fees and the damages, those are statutory, so they're set. So whether or not you get a default or not, well, I mean, the fees are for the other side. So if you default, they're going to be entitled to statutory damages, and they're going to get a money judgment for their statutory damages and their statutory attorney's fees. And you will still, well, so the problem with that, with a default, is they're going to come after you until you've modified the problem. Because every ADA lawsuit you're going to have, there's going to be three things. There's going to be monetary damages, there's going to be attorney's fees, and there's going to be a requirement that you fix the problem. So you'll never get a settlement that doesn't involve all three of those. So if you get a default, what's going to happen is they're going to refer it to the city attorney's office, and then you're going to be within the purview of the city attorney, and that is not a place you want to be. So if you have non-compliant ADA issues and you don't fix them and you don't respond to a lawsuit, you're going to create more problems for yourself than dealing with them in the front end.
Somebody's asking if you could close off a section of the property. If it's completely closed off, I don't have a problem with it. But if some people could go to the roof and others couldn't, that's where you get into trouble. So if you want to close off completely an entire section that nobody could go into it, then it's non-public anymore. Attorney's fees are available per statute. They're going to be very minimal if somebody defaults. So for example, if they filed a lawsuit and they say they did some research and this and that, and their fees are $5,000, right? They bill $1,000 an hour. Then that's, once they get the default, maybe even through finishing it up, that's what their limitation on attorney's fees is going to be. Yeah.
So the question I say, so you're talking about not letting it go to default, but fixing the issue. The lawsuit, they're still going to get their monetary damages. So because the monetary damages attached to the lawsuit at the time that the person went into the place and did not have access to the bathroom and did not have access, that's when the damage is attached. So you not responding but fixing the problem isn't going to change the fact that they're entitled to damages and that they're going to request attorney's fees as well.
When you think about an ADA lawsuit, think of more as a nuisance, okay? So there are law firms out there that all they do is they have these disabled people who go around properties and try to pretend like they tried to park and there was no parking, or go to a bathroom and there was no bathroom. And then these people become their plaintiffs, and they use the same person and file a lawsuit against the store and the restaurant and the multifamily and the office building, same person, okay? Now, these are nuisance lawsuits. They file a lawsuit, they say, give me $2,000, I'll dismiss it. Another lawsuit, give me $5,000, I'll dismiss it. That's what they do. Now they're gonna ask the owner to commit to fixing the issue. And because it's negotiable, they could say the owner is gonna take X amount of time, 2 months, 5 months, 6 months, whatever, and it's gonna be up to the owner to actually fix the issue. So the fixing part is gonna be negotiable, and it's gonna happen way after the lawsuit is over. So there's almost no reason to ignore the lawsuit and get a judgment. You're better off negotiating the fixing time and negotiating down the attorney's fees and the penalties. You could argue, well, you're wrong on the issue. We did have parking. Somebody parked illegal there. At the moment you were there, you didn't see it, or whatever our excuse is. Plus, obviously, you're filing the same lawsuit in every single case you have. You didn't spend 10 hours, you probably spent 2 minutes. So you could negotiate the amount. It's going to be very low. And then you just should fix it because it should be fixed anyway. So don't please don't ignore anything, because when you ignore something, you can't control it. And when you don't ignore it, you can control it. You don't need to hire an attorney to negotiate with these guys. You could just call them yourselves. Obviously, you can't represent an owner because a non-attorney cannot represent another party, but the owner could call them themselves and say, hey, I'm the owner. What's the issue? I don't have a lot of money. Can we just resolve it? And then they'll resolve it easily, and the owner can fix it. So just please don't ignore anything. We wanted to continue to talk a little bit about leases, because that seems to be something that you guys are interested in. So Heidi, do you want to talk about deposits a little bit?
I think I said some of it, that you can't charge a pet deposit on EMS and service dogs, twice the rent for security deposit, 3 times the rent for furnished. Within 21 days after they vacate, you need to serve them with an accounting, which includes receipts, and it shows how the deposit was used. So you can use it with unpaid rent, and then damage that's above normal wear and tear. So everything has a shelf life in a unit. So if you have a tenant that's been there 20 years, you're pretty much not going to deduct anything except for intentional damage. So, they put a huge hole in the wall or things like that. You're going to charge them for that, but you can't charge them for repainting or new carpet or things like that on a long-term tenancy, because like I said, everything has a shelf life. But if it's a tenant that's been there a year and you repainted when they moved in and you put in new flooring and new carpet and they've trashed it, yes, you can charge them deduct it for the, give it. I believe there's actually in the city, they have a breakdown of value for percentage deduction for each year that they're there. And you can deduct that. And then within 21 days, you give them whatever's left over. If there's anything left over, give them the receipts, give them the accounting. If you fail to do that, they can bring a small claims action against you. And technically you're obligated to return that security deposit to them. The way to end run that is to file a cross complaint against them for the damages. So
I want to emphasize something, Heidi. If you guys are property managers, please go read Civil Code section 1950.5. It's probably the most important code section you're going to read as property managers, because it discusses in very details what notices you have to give to the tenant, what they have to say. This is in terms of security deposit issues. And you have to give the tenant the right to basically inspect the unit before, and there's a timing when they have to do it and when you have to give the notice, and they tell you if they're going to fix or not fix and all that. So it's statutory. And then it also talks about the 21 days. And I want to tell you something. I had a class action. My client property manager managed about 900 units, and the class action had to do with the 21 days. And what he did was, my client, he had an on-site repair person, and he had the repair person do whatever the repair was, and then he just added it to a letter and sent it within 21 days. And that's not following the code. The code requires you to do the following. It has to be very specific, like with the notice. Remember we talked about the notice to quit? These things are very specific. If you don't do it exactly, you're toast. So when it has to be 21 days, and it has to say either attach actual receipts. Don't give me the numbers. Give me the actual receipts of vendors who did the fix, or if you had your own people do it, and I don't remember exactly how the code reads, but I think it says something like you have to say who did the repair, how many hours they spent, and how much you pay them per hour, okay? So remember, if you have your own repair people, that's fine, but the notice of the deposit that you're keeping is going to be one way. If you have vendors doing it, the notice is going to be a different way, and you cannot forget to attach the receipts. And then they have time to dispute it and all that, and the code talks about all that. Very important, because if you don't do it properly, they're entitled, I think, to up to 2 or 3 times the entire deposit, plus their damages, and like everything else, I think also attorney's fees. So it just could get a lot more complicated from a little tiny thing that you're trying to do here. So just make sure you read it and you know exactly how to work it up. Late fee, you want to talk about that?
Yeah, City of LA don't charge late fees. Just don't. No judges will enforce it, and if they find in your your breakdown of the rent that's due on an eviction that there were late fees, they'll deduct it, and your notice will be wrong. So don't charge late fees, or if you're going to, make sure that they're not included in your notice in any form, or deduct it. So if you charged, within the last 6 months, you charged 3 late fees, and you want to do a notice to make sure to cover yourself in the City of LA, I would deduct it. But you've got a moratorium anyway. But late fees right now, they have to be reasonable. And I have actually done trials on this issue, and reasonable is determined by the actual cost. So in the case that I had, we were representing property management company, and they charged a $50 late fee. And so we had evidence on whose hand did it touch. It touched the on-site person. Then the manager looked at it. Then what did they make? How much time did they use in looking at it? Things like that. So you have to justify, because it can't be a penalty. It has to be an amount that is justified by the effort that goes into preparing that notice, reviewing the notice, things like that. So I suggest anything over $50 is going to be very difficult to justify. I tell my clients to keep it between 25 and 50. Commercial, it doesn't matter. Usually people do a 10% of the rent. There isn't a limitation on commercial late fees. So bed bugs are your responsibility as a landlord, unless you are absolutely positively sure that it was the tenant's fault. And that's very difficult to show. Really, the only way you can show that, because they are migrating bugs and they go, in through walls and under everything, is if it's a single family home and there wasn't any bed bugs when they moved in and there's bed bugs now, then you can say, it looks like it's you. But if it's a multi-unit property, it is virtually impossible to prove the source of it. And if you charge the tenant, you're going to get, well, especially the City of LA, you're going to get into trouble with the City of LA. But it doesn't make any sense. Okay,
so we said we're going to go for an hour. It's been about an hour. I just wanted to mention cannabis leases. If anybody has questions, feel free to call us. They get really tricky because there's issues about enforcement. There's issue about having the landlord have sufficient insurance that would cover it, and so forth. So just when you think cannabis, you definitely want an attorney to draft the lease between your owner, client, and the tenant. Just think about that. The remaining of the slides that we had here are basically just generally type of claims we see against commercial brokers involving purchase and sales and things like that. Because you guys wanted to talk more about evictions and leases and stuff like that, we focused on that. We're going to send the presentation out to your broker so they could all distribute it. And if anybody has questions, obviously feel free. And if you want us to do another one about more purchase and sale issues pertaining to commercial brokers, we're happy to do that as well. I learned that if we go more than an hour, everybody tunes out and just stops listening. So we'll stop here while we're ahead.
Oh, that was phenomenal, Rinat. Heidi, thank you. Can't thank you enough. It was a lot of information, and we had really good attendance over here and good questions. So again, thank you, and looking forward to get your handouts or whatever information you want to share with us, so I can share with the group. And again, I appreciate your time and knowledge. Thank you.
You're very welcome.
Thank you.
Thank you.
Thanks everybody for watching, and we're gonna share this recording later today as well. So take care and stay safe.
Thank you.
Bye-bye.
Thank you.
Thank you, Heidi. Thank you,
Yep.
Rinat. Thank you, Meny.
Very welcome.
Laura, thank you so much. Laura Peterson, RERM. Thank you.